All right, great. Thanks, Lorenzo. Okay, so morning, everyone. So we are ready.
Okay, thank you very much. Good morning. Thank you for being here. We have today our second day of the Enacting Conference on Article 2 Values and New Perspectives. I welcome today the two speakers of the morning session, Professor Cristina Fasone from Guido Carli and Dr. Anna Wójcik from Kozminsky University in Warsaw. I think you all know Cristina, but it's already mandatory to to tell a short bio. So Cristina is Associate Professor of Comparative Public Law at LUIS, where she is also Director of the BA program in Politics, Philosophy and Economics. And she obtained her PhD from the University of Siena. And she was also a visiting professor at the Nicolaus Copernicus University of Toruń in Poland. Her paper today is on conditionality as a tool for protecting European values. So without further ado, I tell Cristina to start her presentation. I guess I have to speak from the microphone. Okay. So thanks very much. Thanks for inviting me. First of all, to the Giacomo module holder, Giacomo Delledonne, but also to Giuseppe and the friends that are always here in Sant'Anna. So my presentation is going to share some reflections that I've developed also together with another colleague, Marta Simoncini, also based at LUIS. And I mean, quite preliminary thoughts. I've read a lot, including the work of many of the present, but I'm not an expert on conditionality as such, so I'm learning. And the presentation will be structured as follows. I will first highlight some key points of what conditionality is as an instrument of government or governance, some problems that conditionality may trigger, so advantages and disadvantages, and then I will zoom on the EU case where conditionality has evolved a lot over the years, to then deal with essentially the post-next generation EU situation, looking at how conditionality is seen as a tool for protecting European values, so this financial leverage meant to, together with other instruments, that to safeguard values, in particular the rule of law. But maybe there will be a further development. And I think a lot has to be related to how we frame and provide contents to the single values that we see listed in Article 2. Yesterday, many presentations pointed to this fact. Because the rule of law definition that at least the rule of law conditionality regulation provides is quite broad. I don't mean to refer here to the thin or thick notion of rule of law, but rather to the fact that if we draw on Article 2 of that regulation, we can find difficult to disentangle the rule of law as such from democracy, from equality, fundamental rights, protection at large. So maybe this is, we can use the rule of law as a all-encompassing value for the other values as well. I'm not sure, but maybe in the discussion, this can be one of the points. So conditionality is typically compared to typical and traditional command and control mechanism of rule enforcement and rule production, according to a top-down process, whereas conditionality is meant to be more participatory in its design, or at least based on negotiation, on compromise in the definition of the basic conditions, even though the enforcement mechanism can be more or less strict. So it's considered as a way to supplement typical mechanism of production of norms within, especially within constitutional states, federal systems. And despite the typical asymmetry that we see present in the command and control type of decision making, conditionality tends to be portrayed as a more egalitarian or symmetric tool, even though I think this is to a large extent just an appearance, because conditionality always implies an asymmetric relationship to some extent. A symmetric relationship that I think depends on the level of mutual trust between the parties. And this can be seen also clearly in when we compare conditionality in the international landscape as practiced by the IMF, or conditionality within federal states. But here we need to divide, for example, the practice in the US compared to Canada, where it is become almost abandoned as a mechanism to impose federal spending according to a asymmetric relationship. So I think it depends on how much you can trust the recipient of the fund, and therefore how symmetric this relationship becomes. Also, there is a variety of conditionality regimes and types of condition. We can impose positive conditionality, as it is to a large extent under the IRF, or negative conditionality when you withdraw or suspend funds. If you like, this has been also the logic of the Stability and Growth Pact. And I think one of the problems of exerting enough leverage for enforcing the rules. Then we have ex-ante and ex-post conditionality mechanism. Ex-post conditionality mechanism especially has some problems, because once you give money, then it's difficult to claim the money back. So Marco Buti, Messori, many economists have pointed to the problems of this ex-post conditionality. It can be policy-oriented, so refer to the specific policy on which we want the funds to be implemented, or it can be horizontal and crossover, as it is notably for the rule of law conditionality regulation. And in terms of effectiveness, I think lawyers have not carried out a wide reflection on this point yet, because this is much more for economists maybe to assess. But some political scientists, for example, have tried to connect the consistency, the coherence of the conditions, the clarity of the condition, and the predetermination of them, as well as the credibility of imposing sanctions, to the effectiveness of the instruments. Another element is also the evaluation and ex-ante assessment of the adaptation costs to those conditions. So there are a series of elements to be taken into account. And also important is to, I think, reflect on the legality and the legitimacy of the instrument, especially for lawyers, because conditionality always triggers some competence issue, which have been somehow solved in some federal systems. I'm thinking in the US, for example, where the Supreme Court basically conditionality trumps even the competence allocation, as long as there's no coercion, so that conditionality does not represent a gun to the head on the states. But there are, in fact, problems of coercion, as we could see, I think, quite clearly under the strict conditionality during the financial crisis. There is a problem of responsibility, so where the locus of responsibility is, because as long as the conditions are set in a shared manner, it's difficult in the end to ultimately claim that one level of government is responsible only. And there are huge problems, including in the EU, of accountability, democratic accountability, because parliaments are hardly involved, if not in the setting of the condition, and problems of transparency. I found myself in trouble to retrieve the Commission implementing decisions on the suspension or unfreezing of funds, problems of legal certainty, and there is a huge issue with discretion or potential arbitrariness in the way we apply this condition, especially when, as it is now in view for the condition for the Commission, we can play with different conditionality regimes to obtain the same ultimate results. This maybe increased effectiveness, but certainly not the clarity of the ground on which the decision is taken, as long as funds are suspending or withdrawn. Then advantages, I can be quick, I think, on that. Typically, conditions are posed to ensure some uniformity or unity in the legal system, and to also guarantee equivalent living conditions throughout the territory, so they can somehow endorse vertical forms or horizontal forms of solidarity. And they can also prevent or tame problems of externalities and free riding, as I think is also a little bit in the mindset of the Court of Justice when addressing the rule of law conditionality actions for annulment. Also disadvantages because there is a potential encroachment of competencies by the higher level of government on the lower ones, problems of quality of the decision making, which, by the way, the same rule of law conditionality poses, but then is complex to implement the same standard of pluralistic, participatory, and transparent decision making that the Article 2 of the rule of law conditionality regulation poses for the implementation, and can, of course, change a lot the enjoyment of rights. One typical argument, for example, in relation to Hungary is about the rights of the final beneficiaries and those who had legitimate expectation to, for example, receive funds, especially in the university sector. Now, the evolution of conditionality in the EU has gone through various steps. It used to be very much used in EU external action. It has become used as a regular device in cohesion policies since the 1990s, and at the same time was used in between accession and membership of the EU, notably during the accession process, especially towards the east, because in the previous accession cases, there was no encompassing use of conditionality, as we could see under the Copenhagen criteria, with mixed results. So many, for example, have blamed the effectiveness of or the controversial implementation of political conditionality, especially Dimitri Koshenov among the others. Then I think one of the turning points in the use of conditionality was the Eurozone crisis and the endorsement of strict conditionality, including by the Court of Justice, which, by the way, in the famous Pringle case, contributed to pose strict conditionality as a precondition for then the ESM and the revision of Article 136, but did not elaborate, did not have the object was not related to the constitutional implication of conditionality as such. And that triggered a lot of discussion about limited sovereignty or renouncing to sovereignty altogether. While at the same time, as a legacy of the Eurozone crisis, we also had the European semester and the national semester in action. And I think that an important role has been played here, also for the protection of the EU values indirectly, by the country-specific recommendations that in many systems have recommended anti-corruption reforms, judicial reforms of various sorts. One of the problems for the EU is the limited size of the budget beyond the temporary nature of the RRF, and also a problem of the legal basis, which, Hungary and Poland criticized, so the ground of Article 322 as the implementation clause of the budget, but others, for example, Päivi Leino-Sandberg, have criticized also the overstretching of the legal basis for cohesion policy to build and to create the IRF. Since the Next Generation EU, I argue that there has been a sort of normalization of conditionality. Look at it through the federal lens, of course. A lot has to be done then to properly consider the constitutional implication of conditionality, but conditionality has helped to fulfill the typical functions that budgets are expected to fulfill, so allocation, stabilization, and to some extent redistribution. Also because even before the Next Generation EU, the Common Provision Regulation of 2013 already established a connection between the implementation of the Stability and Growth Pact and the potential suspension of funds. And And also, what I can see, but to be subject to further reflection, is the fact that this method of government, the planning method, as someone has called it, stemming from the Next Generation EU, is applied to a number of other instruments and policy areas based on performance-based plans. We also have the new National Structural Reform Plan, the fiscal plan for the Stability and Growth Pact 2024, based on performance mechanism, so a series of milestones and targets on investment and reforms that can extend the net expenditure path. So basically allow the member states to spend more, though we need to wait and see whether the whole construction of the Stability and Growth Pact is going to endure under REARM-EU and alike. So as De Witte put it, there is a new mechanism of integration through funding that is spread across a wide range of policy areas. Now, to come to values instead, I think that at first glance, most of the values, principles we learned yesterday that are listed here are potentially already guaranteed somehow, safeguarded by conditionality mechanism. I'm thinking, for example, human dignity has been indirectly probably, but protected by the triggering of the charter enabling condition under the Common Provision Regulation under Article 18 of the Charter, so right to asylum for problem of violation of the principle of non-refoulement, so problems even of life, right to life even. Democracy, it depends on how we see it, because in my view, under Article 2 of the Rule of Law Conditionality Regulation, as I say in a second, there are some ramifications on democracy as such, and also equality, both for the presence of the Charter enabling condition, but also for the gender equality condition under the Common Provision Regulation. So in particular, we can refer to the equality between men and women and non-discrimination. On solidarity, I think it's more blurred, but the Court of Justice in this famous decision on the Rule of Law Conditionality Regulation build their own construction for justifying the regulation, also on the linkage between the budget, solidarity, and commitment to the obligations under the treaties. So I'm going to focus mainly on rule of law and incidentally on solidarity, but I will try to say something in the end on democracy maybe. Actually, my argument is that the IRF so far and the Common Provisions Regulation have probably been more effective than the Rule of Law Conditionality Regulation itself, as also I think Marco Fisicaro and others have claimed, because of the limited implementation of the Rule of Law Conditionality Regulation, and also the narrowing down of the circumstances in which it can be actually triggered compared to the original 2018 version of the draft regulation. And here we come to this definition. Is it okay or no? No. Okay. Yeah, okay. Because the definition of the rule of law is quite broad. It not only refers to access to justice, of course, independent and impartial courts, but it also refers to non-discrimination and equality before the law, which are other two values under Article 2. It also refers to a large extent, I think, to the democratic decision-making, especially to representative democracy, because it operationalizes the principle of legality as implying a transparent, accountable, democratic, and pluralistic lawmaking process. That I think, as we are going to apply this standard to the various member states, I think just maybe a few of them will meet the standard of a pluralistic, transparent, and accountable rule of law procedure. But we know that we need to relate this provision to the specific scope of application of the rule of law conditionality regulation, which is narrow, quite narrow, because it refers to the breaches of the principle of the rule of law in the member states that affect or are seriously affecting the sound financial management of the union budget and the protection of the financial interests. So it has to be related to problems with EU funds. Many scholars, as well as between the lines of the Court of Justice decision, I think one can read that we need a combined effort between all the various instruments in the toolbox, trying to exploit as much as possible connection and synergies for the enforcement of the rule of law values. That said, the Court of Justice clearly stated that the rule of law conditionality regulation is a subsidiary tool, meaning that we need to assess on a case-by-case basis, comparative assessment, on which of the many tools is going to be the most effective one in order to activate it. And on the conditionality regulation in general, or better, in the use of the financial leverage to protect fundamental values, I think there are two schools of thought, not so far away because there are also many middle ground positions, including Tonia Baraggia and Matteo Bonelli that I've placed here, but because I see that they engage with a pondered reflection on the constitutional implication and the problems that this may trigger, between the transactional approach to the rule of law, so exchanging monies for value, and the other camp, so to say, according to which the economic leverage is crucial and is key to free citizens from the autocrats, having them relied on clientelism and problem of feeding this network of supporters through EU funds. While all scholars certainly agree that we need to fix somehow these rule of law problems. I think one of the paragraphs of the Court of Justice decision in the action for annulment against Hungary, but I think a comparable paragraph can also be found in the other against Poland, is the one that, paragraph 129, that relates the union budget as one of the principal instruments to implement the principle of solidarity, which is one of the fundamental principles of EU law. And here, going back to the presentation of yesterday, we can see that there is this mixture between values and principles that are used somehow interchangeably. And the court goes on saying that the implementation of solidarity through the EU budget is based on the mutual trust between the member states, as we need to ensure the responsible use of common resources. So basically, conditionality is needed to build mutual trust and to then ensure also solidarity. That's, I think, a very not so unexpected. It's a nice construction, but maybe it gives legitimacy to the whole mode of governance that is provided by this regulation. And the mutual trust is based on the commitment, so that you can show that you are committed to comply with the obligation, and in particular the rights, the values under Article 2. So there is an exchange here. You commit yourself to respect the obligation and values in exchange for the EU funds. Is clear the construction, and is based also on the principle of solidarity. So that's also why at the very beginning I said that the mutual trust, I think, is key even in the EU for understanding the functioning of solidarity, of conditionality, sorry. And then the court also comes to say that the enjoyment by the member states of the rights stemming from the treaties including the rule of law, are identifying the very identity of the Union. So it gives a constitutional legitimacy that to the instrument or a constitutional tone that maybe was not that visible, considering how the rule of law was watered down in the content of the rule of law conditionality regulation approved. The Commission guidelines that we know were an outcome of the December European Council, basically, and a concession to Hungary and Poland, are important. They clarify some points on denouncing the violations and the protection of final beneficiaries, but overall were not that crucial. And a proof of that is the fact that the procedure against Hungary started already before the Commission guidelines were approved. The procedure started on a variety of grounds: lack and problems with anti-corruption rules, lack of effective judicial remedies, lack of cooperation with Olaf, and there was a lack of commitment also by the Hungarian authorities. So in the end, 17 corrective measures were agreed after a complex negotiation, which went on for almost a year in the end. In the end, in December 2022, the Council implementing decision was adopted because the serious violation, actually not the implementation of most corrective measures, was detected. This triggered the suspension of 25% of the economic commitments towards the country under some programs within the cohesion policies, and the Commission was prevented from taking new commitments, also with public trust established in Hungary, amongst which I think some universities have been converted to this status under Hungarian law. Moreover, the National Recovery and Resilience Plan was somehow approved, endorsed, but never used. And so the suspension was, in terms of number of funds, broader than the amount of money under the National Recovery and Resilience Plan, especially because the super milestones were not fulfilled. In the meantime, also the Charter enabling conditions were activated under Article 18 and 47 of the Charter. We came to the partial unfreezing of funds in December 2023 for around 10.2 billion euro. But as we all know, that was very controversial because it was seen as an exchange for obtaining the consent of Hungary on the midterm review of the multi-annual financial framework and on the Ukraine facility. And the European Parliament famously brought an action for annulment against this decision, which I think is still pending, but I have not checked lately. In the case of Poland, but Anna will better tell us, also the Charter enabling conditions was triggered, both under Article 18 and 47. I hope I'm not wrong in counting 76 billion euro overall as the suspension of funds. While we had, famously, after the approval of the National Recovery and Resilience Plan, action for annulment brought by various also association of judges against this decision, as the rule of law deficiencies were not fixed at all. Then the attitude and the mode changed completely after the election in October 2023, actually after the appointment of the government, because we had a phase in which the peace actually was claiming that the relative majority in the parliament allowed it to control the parliament. So it was, I think in November, was in the end, and December was the Tusk government appointed, and almost the day after, the Prime Minister asked for the pre-financing, and then under the National Recovery and Resilience Plan, and then the payment of the first installment. In the end, Poland got the unfreezing of all the funds suspended, and the payments already of 2 installments under the National Recovery and Resilience Plan, with the third that was asked in December 2024. So a lot of discussion as arose around the issue of double standards between Poland and Hungary, also because when Poland asked and then obtained the payment of the first installment, please, Anna, correct me if I'm wrong, but it was notably an action plan on the reform of the judiciary to be proposed. Whereas for most member states, when you need to claim that a milestone has been met, you need to prove that under the official gazette, the law has been published and then it's implemented. So we can see probably a difference in treatment, but it's also true that this is, after all, a political instrument that allows to be fine-tuned and used in a way that help to restore the rule of law. So I'm not totally, critical of this approach of the Commission, which for sure has become a completely political actor, as we listened also yesterday, and it's not just about that. Now, concluding, I think this governance by conditionality will stay with us, regardless of the destiny of the IRF. And we can see it also under the Reform, Stability and Growth Pact, the various instruments to support Ukraine. There is certainly an increased interdependence between EU funds and national budgets that we could not see before, but the problems is all about funds, as a system of fiscal federalism in the making is not just about spending, it's also how you finance the spending. There are big doubts in the background about competence creep and overstretching of legal basis, which we can hardly fix because I think the treaty amendments are not politically feasible these days. But in general, I hope sooner or later the Court of Justice will be given, or it takes it, the authority to clarify some points about the relationship between conditionality and competence, specifically about limits to also to the Commission action, like devising a Dole test, which is the test used in the US on coercion in European terms, and maybe also on the protection of final beneficiaries. All in all, there is this inherent tension between technical assessment and political discretion in the implementation of conditionality, despite the fact that the Commission has tried to be or to show itself as impartial and neutral as possible through a variety of scoreboard mechanisms to count the suspension of funds. There is, however, a lack of legal certainty, in my view, and predictability. What we can expect. If not, and we can maybe predict what the Commission is going to decide based on ongoing political developments and the political mood. And this is further complicated by the possibility for the Commission to play with multiple conditionality regimes. As they increases, I think we can see that even more present, also for the rule of law. And there is a further increasing of executive dominance. So the European Parliament is very weak in the whole process. It tries to react. So certainly it's very vocal, but in the implementation of the EU budget, it has little voice. It's not under the discharge procedure. But one of the big points is that many of these new funds are not put under the internal assigned revenues, so they somehow escape the traditional parliamentary control. What's next? Maybe targeting democracy. I see some developments here, Commission versus Hungary standing, but also the judgment against the Czech Republic and Poland, I think, on the alleged violation of Article 22 of the TFU in connection with Article 2 and Article 10 or 14, now I don't remember anymore, I think is interesting, as well as the charter provisions on Article 39 and 40, to maybe provide, especially under the charter enabling condition, potential leeway for the EU to intervene also on national democratic procedures, although what is left compared to the rule of law notion, probably, to democracy is just the idea of electoral democracy and fairness of the electoral procedure, because I see also, for example, media freedom covered somehow under the rule of law understanding that the EU gives. So, thanks for the attention, and I'm done.
Thank you very much, Cristina, for this very dense, rich presentation. I think one of the most worrying part of your presentation is the fact that the parliamentary control is very limited in this whole process. So I would now ask Dr. Anna Wójcik to move on with her presentation on restoring the rule of law, opportunities and risk, and see if there is any beacon of hope in this.
Yes, I will just go here. Thank you very much. Right, thank you. So, so I was really happy to be able to summarize and try to. Oh, sorry. Why this is? How do I change it? Ah, just. Yeah. There are two activated. Oh. There are like two. There are two presentations on. That's.
I think it's working.
Yeah. Okay. Perfect. Yes. So try to synthesize and analyze actually how the process is going in its first year and a half. So as it was already mentioned, the government started working in December 2023. Okay, sorry. And we have seen many factors that are influencing actually what is happening on the ground. And my presentation is not that much legal in the sense that those factors that will eventually impact the solutions that are chosen are more political, ideological, and societal. And I will try to explain and also counterbalance some narratives that have been discussed a lot in international fora regarding what solutions should be taken and why. So we can summarize at this stage that the ideological dimension of the current governing coalition is really important. So this coalition is composed of 4 parties who range from center-right to the left. And there is also a conservative traditionalist right-wing party. And these parties, they diverge on many important issues, such as abortion, LGBT rights, or taxation, or housing policies, etc. However, there is a broad agreement that they are the pro-rule of law parties, and they are also pro-European parties, meaning that they don't see any conflict between the Polish constitution, the European Union law, and the European Convention on Human Rights, which is, of course, in stark contrast with their predecessors. So they also, at least in the first year, have given a chance the idea of the rule of law technocracy, so that they hired for the job of the restoration of the rule of law people who are experts. Of course, you know Adam Bodnar, but there is also Maciej Berek, an expert on legislation, who is a very powerful deputy prime minister and the right hand of Donald Tusk, trying to find legal solutions to the mess and to justify the government's actions, because these actions are limited due to institutional and political factors. However, whether this pro-rule of law orientation is really thin or thick, it really depends on the area. And we have seen that it's really thin in migration policy. It's thin in procedural terms when it comes to the overtaking of the public media. And for the moment, it's thick. The promise is that it will be thick when we discuss judicial independence. So it's also important to note that the government is not working in a vacuum, and there is this important societal dimension. So we can also say European society dimension of the whole process. There are powerful judicial associations that have gained a great prominence because they were mobilizing this civil society response to the rule of law backsliding, and successfully. There is also finally a pluralism of opinion in the pro-rule of law camp, meaning civil society organizations, experts, people who are discussing what actually should be done, because the goal is known, well known. However, how to reach it, this is the topic of intense debate. There are also great demands of accountability for what happened during the previous governing coalitions to terms in power. And this is impacting a lot the debate of whether we should trust as a society. We should trust what, for instance, Justice Minister is doing. So the demands of accountability mean that there is a demand for criminal prosecution of certain actors, politicians, people who hold high public offices for corruption, abuse of power, etc. And so these processes are ongoing. However, they are very slow, and these are the limits of liberal democracy that demonstrates that unfortunately this desire for fairness and justice cannot be delivered just in a snap way. There are at the same time the demands for the ending of the constitutional crisis and demands for increased efficiency of the justice system. So this reform, as I would like to call, is not about the rule of law restoration, not about non-regression, but all about the progression. And it's limited currently by institutional dimension. So cohabitation with President Duda, who is finishing his second and final term in August this year. And he has used the risk of the presidential veto, but de facto he has been using more of this unofficial veto power, which means in the Polish current context, issuing motions to the Constitutional Tribunal to verify constitutionality of bills that are adopted, which means that he is preventing the bills that are adopted in the Polish parliament from entering into force. And the opposition also has tools to contest the policy and the narratives, because the PIS and Confederacja, they are the biggest opposition parties, and they have powers to also bring motions to the Constitutional Tribunal. So this situation is not a situation of a normal transfer of power in a democracy, because all is colored by this big entrenchment of loyalists, of hijacked institutions within the system. So this impacts the mode of governance. Plus, there are those powerful narratives of the opposition, the PIS, which is promoting a narrative of a coup d'etat, or, as President Duda said, the terror of the rule of law, which means the government's actions are argued to be in the defense of the rule of law. But in fact, we have seen that this vocabulary, the notions, the values are now used by the party that used to abuse them in practice, but now they try to argue using the same words for different practices. So if from the rhetorical level, we can discern some general direction of the reform in the first 1.5 years. So what is promised is to stay within the limits of the law, to do the reform as fast as possible. And this is a principled approach, but also a political one, because of the presidential elections this year and the fact that the next election parliamentary election should happen in 2027. The progression, not non-regression. The execution of the European Court of Human Rights and the EU Court of Justice rulings, the fact that the reform should be future-proof, which means that it should not be easily contested before the European Court of Human Rights, for instance, in individual cases brought by individuals that would be affected, and to make it even more difficult, it should not slow down the effectiveness of the already inefficient justice system, which is the measure that the Polish voters would most likely evaluate the whole enterprise on. In early spring last year, so more than a year ago, Adam Bodnar presented the action plan to restore the rule of law in Brussels, and this promise, the good impression was was enough to unlock the RRF money and also to close Article 7 against Poland, which also changed a lot the discussion in an institutional way about the rule of law situation in Poland, because we don't have any transparent discussion format such as Article 7 hearings. Now we are only limited to the normal standard rule of law procedures, and of course the dialogue of the government with the Commission, which unofficially is happening, but it's not that much open to the public. So there is this also problem of transparency with how the Commission is evaluating the restoration of the rule of law. As you mentioned, it was really difficult to receive their arguments why they decided to actually close Article 7 well, with the RRF, we can argue that, well, the practical steps were taken to fulfill the milestones, because milestones were also very narrow and they mostly concerned disciplinary responsibility or the disciplinary regime for judges. So the action plan is a set of reforms, planned reforms, bills to be adopted, around a dozen of them, depending on how you calculate. And the status as of today is that so far, the mode of governance is to try to bypass this presidential veto or sending bills to the Constitutional Court by adopting some soft law, which are parliamentary resolutions that are not binding to all official organs, I mean, but they should be guided by them. But then they are a way of template for other institutions to try to go in the direction that the reform should be going. For example, the Commissioner for Human Rights withdraw positions in cases before the Constitutional Tribunal after the soft law, the resolution of the same was passed that said that the Constitutional Tribunal is not an independent body, and there is an illegal composition of it, and the panels with illegal doubles, they do not produce rulings that have that are valid, that should be valid. What was achieved so far is passing the bill on the National Council for Judiciary and 2 bills on the Constitutional Court. And also currently we are in the process of intergovernmental consultations of a bill that would separate the function of the Minister of Justice and Prosecutor General, and that would be a form of execution of the European Court of Justice judgment and the famous opinion of Advocate General Bobek, who said that there was a devilish fusion of the Minister of Justice and the Prosecutor General functions. However, this is not very impressive, I would say, for 1 year of legislative work. So the reform in practice is that a lot of resources, intellectual resources, are used on circumventing the limitations, which means that it's rather signaling through soft law. It's the governance without new legislation, which is focused on the new interpretation of the existing law or on non-application of the law that was changed under the previous government. Personal changes, such as the change of presidents and vice presidents of courts, who are powerful, who have many important functions, especially in the disciplinary system. And also putting a brake on pumping more illegally appointed persons to the system by also a legal maneuver of not opening competitions for judicial positions. So this happened last year, and this means that we have hundreds of vacancies that are not filled because the current government does not want the still flawed National Judiciary Council to recommend people to judiciary. There is also this practice that was criticized by the Venice Commission of ignoring the Constitutional Tribunal's rulings, and the government in the first months, has decided to publish the judgments of the Constitutional Court with an annotation that the rulings are some rulings are handed in a lawful composition, and that is against the rulings of the European Court of Human Rights. However, after they adopted the soft law, they stopped publishing all judgments altogether, including those few that are handed in properly composed panels. And this practice was criticized by the Venice Commission, and the two opinions of the Venice Commission are an important element of the discussion of how the rule of law in Poland should be and is restored. So there is also an involvement of transnational expert bodies in the discussion. So the ministry is asking the Venice Commission and the OSCE audit for their opinions. Also, the Parliamentary Assembly of the Council of Europe has recently asked for opinions on their own regarding two variants of a bill on regulating the status of judges that I will discuss. And the approach of the Polish government to European institutions has also changed. So the official positions of Poland in pending cases before the EU Court of Justice and the European Court of Human Rights are gradually changed. And also Poland decided to settle dozens of cases before the European Court of Human Rights, which relate to the applicant's rights being breached by panels of the Supreme Court in illegal composition. So basically, Poland decided to pay to the applicants 20,000 euros and to therefore limit the number of pending cases before the European Court of Human Rights. So they generally agree with the positions presented, for example, by the European Commission, or in the individual cases, they may agree in the positions brought by the applicants. However, there are also risks, important risks. And I believe that in the debate, especially academic one, the academic debate has been really drifting away from the principled solutions in order to try to legitimize as an approach that that leads to picking one preferred solution, even though we know that there are alternatives which would be maybe more time consuming, but within the boundaries of the law. So the principled approach would definitely focus on legality, legal certainty for individuals affected by the changes, predictability of the law, and also constitutional and the European Convention on Human Rights guarantees to people whose rights would be affected by the changes, meaning judges of the common courts and the Constitutional Tribunal. However, this risk, another risk, is that there are important voices in the academic debate, such as Wójcik, but also Kimlane-Szepele, that advocate they want to convince the Venice Commission that the approach that they took is not really in line with the real demands of this very unique situation that is happening in Poland, and therefore that the Venice Commission opinion on how to regulate the status of neo-judges should be reversed. But this is, I believe, an approach that that is far removed from the current stage of the policy process that is happening on the ground in Poland. But this narrative is taking a lot of prominence in academic blogs, at conferences, and it's not that much reflective of the current very specific, detailed discussions on how to actually devise mechanisms to achieve those goals. So I just wanted to emphasize that although this discussion of whether we can break the law to restore the rule of law is very intellectually stimulating. We should rather focus, and this is what I believe the government is trying to do, on devising something that would be within the limits of national law and also European law. One of the big risks is also this initial thinking that perhaps the mechanism of restoring the constitutional order should be somehow merged with also the mechanism for accountability. For instance, abuse of power by judges or by who were presidents of courts and who are responsible for disciplinary offenses. And at the early stages of the discussion of how to clean the mess, there were some ideas that, we should link the individual flawed appointment with the performance of a given person, of actions taken not only as a judge, but also, for instance, against colleagues who were trying to defend the rule of law. But I must say that I think today we are beyond this approach, and the discussion is focusing on more specific problems, unique problems, and we know just much more how to approach these unique issues. So what is unique? Of course, the unique issue is that there is an unprecedented questioning of the status of the current Polish Constitutional Tribunal as independent court under EU law. And there is also a problem of the status of more than 100 rulings handed by this court in defective panels. Defective panels meaning including 3 doubles, persons who took positions that were properly assigned to people selected in 2015 by the parliamentary majority that preceded the PIS majority. And it's also unprecedented that we have a constitutional court which has been assessed by the European Court of Human Rights in Xeroflor versus Poland, in the way that panels with these doubles breach the applicant's rights protected by Article 6. And we also have a case, ML versus Poland, that was a case concerning the abortion law restriction. And the Strasbourg court said that the judgment restricting abortion law was handed in a way that does not conform to the rule of law. So we really have this unprecedented situation. We also have this pending case at the EU Court of Justice. We discussed the Advocate General's opinion yesterday a little bit. So this creates this clear legal obligation on Poland to reform the Constitutional Tribunal. And there is, at this stage of discussion, there is no argument about it. So it's clear that this has to be done. Another clear obligation relates to the regulation of the status of more than 2,500 judges who were appointed or promoted with a varying degree of involvement of the politicized National Judiciary Council. And this is the topic that at the moment provokes the most heated debate, and also those arguments that maybe we should break the law to restore the rule of law. So at the beginning of the debate, most people thought that this is a uniform category. And today it's agreed that we should differentiate between various categories, how people actually entered into the judicial profession. So the solutions that were discussed at the beginning, in the case of the Constitutional Tribunal, there was a radical solution. So radical solution would mean zeroing out the court and firing all 15 judges of the court and creating it anew. But this is impossible, or maybe even scrapping the court. So scrapping the court is impossible because the Constitution says that we have the Constitutional Court, and the argument that all 15 members are infected by illegality because they ruled in those panels with the 3 doubles also was considered too radical. And in the solution that was actually adopted by Parliament, we only have the removal of the 3 doubles. Currently only 2 remained, because also the time passes, so there are new vacancies, the terms of office change. And there is this method of a carrot and a stick. So the idea is that the stick would be to change disciplinary rules for judges so that perhaps the new disciplinary commission for the Constitutional Tribunal judges that would be composed also of the retired Constitutional Tribunal judges can, for example, verify whether the conduct of the current judges breaches the ethics code or not. And this is the stick element of the plan. The carrot would be various incentives for the current judges to resign. So the bill allows them to resign without providing any grounds, and they would keep their very lucrative retirement pensions. And this is an idea that that should speed up the process of rotation of creating new vacancies in the court, which means that it will speed up the process of having majority in the court. However, even having majority of people who would be appointed under the current coalition won't solve the main problem of the power of the president of the court. And the new president of the court, appointed last December, would be the president until 2030. And he's still a person who was very closely associated with the former justice minister, his right hand, the national prosecutor. So the idea of the new reform is to also change the scope of the court president's powers and to take the allocation of cases from him. Because if in the current legal order, he still has power to allocate cases, no matter if there would be majority in the court soon, the outcome, so the possibility of allocating cases to the panels that would rule in favor of the PIS policy is still real. So I believe that the approach that is presented in those bills on the Constitutional Court is hopeful, correct. It's presenting a gradual change of the composition of the court, but for the moment, these solutions are of course not implemented, and also the government is ignoring the court. It is also not proposing new candidates to become judges of the court. So we are still in this limbo waiting for the outcome of the presidential election. And then if the new president is willing to sign those bills, we will see how the gradual solution will work in practice. But it will be a long healing process. And it will be also really interesting to see how this current judges of the court, how they react, would they oppose, etc. The other problem about the neo judges, we have various categories of them. So there is an agreement that the biggest group of young judges, so people who went through the school for judges or they were referendaire in courts, their status would be regulated without any sort of verification, because the NCJ was only marginally involved in the process of their appointment. And this is a way of answering also to this demand of effectiveness of the justice system, because the radical solutions presented at the very beginning was that 3,000 judges did never acquire a judicial status, they are not judges, and there were, in the Polish internal discussion, there was a lot of stretching of the arguments presented by the EU Court of Justice and the European Court of Human Rights, because the case law of those courts does not say that these people never acquired the judicial status. So after 1 year of intense discussions, we have an agreement that yes, indeed, these people are still, unfortunately for some members of judicial associations, they will just remain in the system. And this includes 1,200 judges who were already appointed before 2018 and later were only promoted. So the idea is there is also a debate, a doctrinal debate, that we should differentiate between them and the judges that were appointed before, and that they should be demoted to lower positions. There is also another group, a group of around 300 people who weren't judges before 2018, who entered the judiciary from other legal professions. And the idea is that they should be removed at all from the profession. And then there is the question of 55 neo-judges of the Supreme Court, so 60% of the whole Supreme Court, who are in all 5 chambers, the 2 ones that were added by the PIS, but also in the 2 old ones. And the idea is that, yes, that they should also be removed, or to the previously occupied judicial positions, or if they were academics, they should go back to the universities. And now how to do it? So now the discussion is about the mechanism. And there is this solution that is advocated, for instance, by Professor Sandurski, Tim Lane-Shepele, Associations of Judges Justitia, that a single statute should be passed that would regulate the status of those groups, and perhaps they can have recourse to judicial procedure, so they could appeal this decision. This is contrary to the Venice Commission's opinion that was issued last year, and this is the reason why there is this attack on the Venice Commission by eminent constitutional law scholars today. The other solution would be to introduce a mechanism of individualized verification before the new National Judiciary Council. And this is a solution that seems to be more moderate and also more in line with what the Venice Commission has suggested, that the process of verification should happen before a body that is independent of the government. So this solution would require establishing of the new National Judiciary Council. So again, all depends on the president. If there is a president who's willing to sign the bill, let's say in August, then in January next year, we will have the new National Council for Judiciary, and this council will assess individually those 1,200 statute judges and those persons who enter judiciary and the neo-judges of the Supreme Court. And now the debate is on how to do it, how to actually improve those 2 variants, those 2 scenarios that were presented. So I believe that to conclude, because I don't believe that this process is finished, it's just in medias res. So what impacts the process of the restoration of the rule of law in Poland currently are, of course, those institutional limitations, political considerations of coalition partners, dialogue with European institutions such as the Venice Commission, and also the ability to craft solutions which would be at least to some degree accepted by the persons affected. I believe that the risk of illiberals returning to power is great, and that means that the adopted solutions should strictly fit in the boundaries of national and European law, and that we should really take into account this possibility that they would be contested before the European Court of Human Rights. So I'm really looking forward to your comments. As you can see, in practice, of course, the judgments of the European courts that we discussed in discussion on the values in Article 2 is important, and they offer certain guidance. However, this guidance is in practice very limited, and there is still a lot of leeway, a lot of possibility to craft specific mechanisms. I only hope that it won't be done contrary to advice that is sought from European institutions. Thank you.
Thank you very much. I forgot to mention that Anna Wójcik is assistant professor and principal investigator of a research project on media regulation and freedom in member states at the Kozminsky University in Warsaw. So thank you very much for your presentation.
Because you are the very, very good. Okay, so welcome back. Welcome back. I'm very happy to chair the last panel of the day and of the conference. Faraguna, please behave. So I'm very happy to share this panel. We have two presentations, one given by the professor Francesca Del Monte. She's associate professor of constitutional law at Sant'Anna School of Advanced Studies. She's a pillar of the Sant'Anna Legal Studies program. She's a friend and above all an expert in this field. That she recently had the big project on migration law and the asylum law in the legal framework of the European Union. And she was also the main the principal investigator that in some other EU projects. She also had the Jean Monnet module on that. So I'm very happy that she accepted to join us for this conference. She's going to talk about Article 2 values beyond national, constitutional. I don't see the national, the constitutional crisis values. Thank you. The European migration law, and then after that we will have Professor Nikos Skoutaris, who is a professor of law at the University of East Anglia in Norwich. Prior to joining the University of East Anglia, he was, among other things, the postdoc fellow in Tilburg, assistant professor in Maastricht. He was part of this big UNACOM project led by Monica Klaes. He's an expert in many things. He also covers EU external relations, the comparative federalism. He's a very eclectic scholar. Another friend, I'm super duper happy to have you here, and they will talk about the Article 2 values and the withdrawal from the European Union, taking the Brexit. Brexit as a case study, probably. Well, thanks so much also for joining us. Having said that, I give the floor to Professor Francesca Biondi. Ready to where you are.
Thank you very much, Giuseppe, for this kind of presentation. Thank you to Giacomo for the involvement in this interesting Giacomo module. I'm very happy to give this presentation about values in European migration law. Okay. Yeah, first of all, I start from Article 2 of the Treaty on the European Union to give you an overview of the protection of fundamental rights of migrants in the European Union at European Union level. Giving a reference to the Charter of Fundamental Rights and to the European Union law, the provision of the Treaty on the function of the European Union, and some legislation, in particular some directives and regulation adopted at the European Union level. Then I tried to combine this analysis with some data about flows of migrants to the European Union to underline why in the Pact on Migration and Asylum, adopted last spring, May 2024, we found some provision that put the values of the European Union increases in a certain way. And then some conclusion about taking Article 2 seriously. So, first of all, I think that it's important to recall the provision of Article 2 on the Treaty of the European Union. The Union is founded on the values of respect for, just to underline some very important words and expression, human dignity, freedom, democracy, obviously, but also equality, rule of law, respect for human rights. I think these are really important expressions, and I think that the challenge is to verify, to assess if these values are really taken seriously in the legislation, in the new pact, especially on migration and asylum. And these values are also common to member states in a society in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between human and man prevail. I was wondering if this last statement is just more according to recent event,
should be posed as a question. Are these values really common to the member states in a society in which pluralism, non-discrimination, tolerance, justice, and solidarity are prevail? So yeah, this is the question. And when we try to analyze the protection of fundamental rights of migrants at the European Union level, we have also to refer to the Charter of Fundamental Rights of the European Union, where some rights are recognized specifically to European citizens, other rights to all people that are present in the European Union. In particular, dignity, life, prohibition of torture and inhuman or degrading treatment or punishment, prohibition of slavery and forced labor, respect for private and family life, and in particular, another important provision is the right to asylum, Article 18. The provision recalled the Geneva Convention, obviously, of 1951, and its protocol relating to the status of refugees and in accordance with the Treaty on the European Union and the Treaty on the Functioning of the European Union. So an important provision, and it is strictly connected with the common European asylum system set up in the framework of the legislation. The Charter of Fundamental Rights is a milestone. We have to put the Charter together with other important acts, the European Convention on the European Convention on the Protection of Fundamental Rights in the framework of the Council of Europe, and the constitutional tradition common to the member states. So these acts are define the protection of fundamental rights in Europe. Regarding the declination, the implementation of this principle in the legislation, we have to consider firstly the competencies of the European Union regarding migration. And in particular, now, after the Treaty of Lisbon, the Title 4, Area of Freedom, Security and Justice of the Treaty on the Functioning of the European Union. This title is opened by Article 67. The Union shall constitute an area of freedom, security and justice with respect for fundamental rights. So we find an important statement really linked with the values of the European Union and the different legal system and tradition of the member states. Then we have in Article 78 and 79 the area in which the European Union can adopt specific acts for the protection of asylum seekers and the recognition of international protection, and in the area of migration, economic migration, labor migration, condition of entry, stay in the territory of the European Union. And in particular regarding asylum, Article 78 states that the Union shall develop a common policy on asylum, subsidiary protection, temporary protection, with a view to offering appropriate status to any third country national requiring international protection, and in particular ensuring compliance with the principle of non-refoulement. We have a specific area in which the European Union can adopt regulation or directive, status of asylum seekers, the condition to grant protection, procedure, reception of asylum seekers. So we have many directives in this area. And related to migration, Article 79 defines the area in which the European Union can adopt legislation, and in particular the condition of entry and residence, the standard on the issue by member states on long-term visas and resident permit, but also the definition of the right of third country national residing legally in the member states. This is important because sometimes some provision related to discrimination of third country national in national member states were defined not consistent with the provision of equal treatment included in some directive of the European Union. So it's really important, this area. But also to prevent and contrast illegal migration, combating trafficking person, etc. And finally, last but not least, the important provision of Article 80 of the Treaty on the Function of the European Union regarding the principle of solidarity and fair sharing of responsibility. This title ends with this provision: the policies of the Union set out in this chapter and the implementation shall be governed by the principle of solidarity and fair sharing of responsibility. You know that one of the main issue related to the relation between member states is the burden of the reception of migrants, and in particular asylum seekers in the European Union, especially in relation to the application of this so-called Dublin regulation, the regulation that set up the competencies in the reception and in the procedure for the international protection, for the recognition of international protection. And obviously the rule that put the competencies in the states of the first entry of migrants in the European Union give to some member states like Italy, Greece, Spain, a major burden on of the reception of asylum seekers. So the question is how we can implement really effectively this principle of solidarity, that it is connected with the values of the European Union. And I just mentioned some important directives related to migration and asylum, but just to give you a very, very short overview, we have from the early years of 20s to 2000, some important directives on family reunification, long-term resident, victim of trafficking, sanction directive against informal labor market. And regarding asylum, we have two phases of the common European asylum system in the first year of 2000 and from 2011 till 2013. So, and now in this phase, we are waiting for another important revision of this huge legislation, because with the new pact on migration and asylum, important acts were adopted related to the area of asylum, screening at the borders, and detention of migrants. So from 2026, the June of 2026, a new piece of legislation will be implemented, just in force, but the application starts from June 2026. So, just to give a sort of link between this legislation, the first phase of the legislation and intervention of the European Union in this area, and some data. Migration covers an important part of the policies of the European Union. In 2023, we have more than 400 million inhabitants living in the European Union, and about 70 million people were non-European Union citizens. And more than 6 million immigrants entered the European Union from non-European countries in 2022. While irregular migration is often in the spotlight of the attention of the policies, of the worries of the member states, the reality is that irregular entries account for a small fraction of migration in the European Union. We also have many asylum seekers. So in 2023, we have more than 1 million applications, and most first-time applications were lodged in Germany, then Spain, France, Italy, Greece. And the European countries granted protection to at least more than 300,000 people in 2023, and more than at least around 1 of 10 were unaccompanied minors, and many asylum seekers are also under 18 years old, especially came from Afghanistan, Syria, and Somalia. So strictly in line with Article 18 mention of the Charter of Fundamental Rights. And if you see the top nationalities, 50 nationalities of applicants, you find Syrian, Afghanistan, then Turkish, Venezuelan, and so on, just to underline the fact that it is not an option to grant asylum seekers. It's a duty, it's an obligation stated in the Charter of Fundamental Rights and at international level. And now this graphic is really interesting in order to also maybe assess or try to understand why the approach of the European Union changed in some particular years after the so-called migration or migrants crisis, refugee crisis. If you see the first-time asylum applicants in the European countries from 2008 till 2023, you see a peak in the years 2015-2016. Here, more than 1 million asylum application. And also in the recent years, you will find this number increasing. So it is why we have some really difficult situation also at the European level, also related to the agreement, the relation between different member states, the approaches. So, and especially in the first crisis, so-called crisis in 2015, we spoke about this crisis and a stress test for European values. Also, the scholars stressed this question, the values that are at stake in this particular moment of the European Union history. And at the same time, the fact, United States, for example, stressed the fact that refugees, it is a crisis of solidarity. In this year, for example, we have an important program adopted at European Union level, the relocation program, that was stressed as a solidarity in practice. Asylum seekers, asylum applicants, and beneficiaries of international protection transferred from the country of first entry to other countries in order to share burden, to have a possibility for state to have minor pressure in the reception of asylum seekers. The number are really low, only in total, 34,700 persons have been relocated from Italy and Greece to other European member states, European countries. But this program stimulated a very was at the origin of a complex situation with the so-called Visegrad Group countries. In particular, we had a refusal of the Visegrad Group countries to respect the emergency relocation scheme for refugees. And we have an important first decision of the Court of Justice in 2017 after where the Court of Justice had the opportunity to underline the legitimacy of this program and the need to observe this program, even if this decision was commented by scholars, in particular Labelle in 2017, as a decision in which the values, in particular solidarity, was not put at the center of this decision as a background of the whole program. And after that, we also have another important decision of the Court of Justice, recalling the need for Poland, Hungary, and Czech Republic to fulfill their obligation under European Union law, because they at the beginning refusing to comply with the temporary mechanism for the relocation of applicants for international protection. So two important decisions of the Court of Justice, even if maybe the solidarity was not at the center, maybe in order to find a sort of balance with different approaches at the European Union level. But the scheme, the relocation scheme, was defined and in line with the competencies of the European Union and the provision of the treaty. Another important part of the activities of the attention is of the European Union is related to the prevention and contrast of irregular migration. If you see the data, for example, you have more than 300,000 irregular border crossing in 2023, increasing compared to 2022, and in particular sea crossing, and also land border crossing. So we have also these challenges for the European Union, and this is at the center of a sort of compromise adopted at the European Union level. Here some data with the new Pact on Migration and Asylum. Here you can find also other data about the crossing, irregular crossing related to the route, Central Mediterranean route, Atlantic and Western Mediterranean routes, Eastern Mediterranean routes, and so on. And considering the number of order to leave expansion measure more than 400,000, only 83,000 people, non-European citizens, were returned. So also the efficacy of the return policy is a really challenge at the European Union level. And now maybe this complex situation in this framework, in 2020, the Commission adopted a communication related to the new Pact on Migration and Asylum. The President von der Leyen announcing this pact said that we will take a human approach. Saving lives at the sea is not optional. So the statement really important. And those countries who fulfill their legal and moral duties or are more exposed than others must be able to rely on the solidarity of the whole European Union. So the principle, the intention were really positive. The implementation, not. Maybe we can discuss. It was difficult to find a balance and agreement at the European Union level. And reading the pact is really interesting because we find 3 times the word value, the link to values. The first is the fact that this piece of legislation, really a huge amount of acts, really, is fully, this is a statement of the pact, of the communication, is fully grounded in European values and international law. The first interesting point. The second, another part of the pact, when we discuss about the management of migration, is an effective and human way, fully in line with our values. But it is interesting, another point in which the European values is mentioned at the end, where finally, it needs the engagement and commitment of all. That is why the new pact has been built on careful consultation with the European institutions, member states, and with stakeholders. It is grounded in our values, but we also provide the result needed. So I maybe try to underline this but. Why but? It is a sort of not perfect. If we respect value, we are not, in the sense, efficacy in our action. Maybe we have to, do a balance also, the result of a balance of interest and needs. So it's a question also for the debate, but it is interesting, this word. It is impossible to go through the analysis of all the acts adopted in after four years of activity of the European Union institution, because from September 2020 till May 2024 we had the activities of the European institution was really hard, difficult, and in the last spring, these are the acts that were adopted. Just to have a very brief overview, the Asylum and Migration Management first of all, we have mainly directive, and now we have mainly regulation, only one directive on reception condition. So we have the regulation. The idea is to guarantee a sort of uniformity at the European Union level related to the management of migration. So we have a new Asylum and Migration Management Regulation, an Asylum Procedure Regulation, and a Return Border Procedure Regulation. We have a Crisis and Post-Measure Regulation, and now a new Eurodac Regulation, a new Screening Regulation, a new, sorry for that, but just to give you the idea, a new Qualification Regulation, a Reception Condition Directive, the unique directive, and a Union Resettlement Framework Regulation. Again, qualification, reception condition, yes, no, okay, just to underline some critical aspect to conclude my presentation. This legislation may have a positive impact for the uniformity, for the standard at the European Union level. We have different approaches, different decisions. So we have a problem at the moment in uniformity at the European level. But at the same time, some provisions are really could be questioned, some provision, for example, related to the screening procedure at the border, the collection of a lot of data of migrants using, for example, also biometric data, fingerprints and other data, also from 6 years old, so also including the children from 6 years old. We have a strong, we have the accelerated procedure at the border at the center of the procedure for international protection. So the European Union stressed the fact that the procedure has to be faster, so not and this could be really difficult for the right, for example, of defense to the access to judge. And also the solidarity, it is impossible to go okay in detail, but there is not a real new fresh start was a slogan at the beginning, in the sense that a common sharing of responsibility. So we have to monitor also the implementation of these important acts in the next years to understand how this provision could be implemented, because in the legislation we found important linked to European values. But the challenge is how this legislation will be implemented. And now also the framework is critical. For example, the screening at the border, the collection of this huge amount of data, the value at stake, human dignity, respect for human rights, rule of law. So these are the value that are at stake. Another problem, the accelerated procedure. The body, the commission that are competent for international protection procedures to take a decision in 7-15 days. So the period is so short. So how we can protect also the respect for human rights, the rule of law, the access to judge. So there are many problems. And the last point is the detention at the border. Also, the procedure must be or should be the border will have a central role for the decision on international protection, and the people has to stay at the border of the European Union during this procedure, and also the detention will be improved also for asylum seekers. So again, freedom is a value of the extrema ratio of the detention are really at the stake, and at the same time could be violated for this approach. So I hope that it could be useful to have an overview of the values that we have to monitor carefully in the next year. And thank you very much. Sorry.
Thanks so much also for respecting the time allocated to your presentation. It's very interesting also to take into account that we know that in these days the Commission is working on what they call the new approach to returns, and the news we've been reading are quite, I would say, worrying. So I mean, I'm sure that we will discuss about that. And now afterwards, but now it is time to give the floor to Professor Skoutaris for his presentation, Article 2 of the Treaty of the European Union and withdrawal from the European Union. Thanks, Nikos.
Well, thank you very much for the invitation. It's always a pleasure to come here to Pisa. Congratulations, Giacomo, for concluding this project, and thank you very much also for shielding us from this imminent catastrophe that is gonna destroy Pisa. So, okay, we are late. I was asked to speak about Article 2 and the withdrawal from the European Union. Let me start by saying that I am not an expert on constitutional values or on anything else, but I have worked a bit on the whole Brexit process and the withdrawal from the EU. So what I thought I would do is, first of all, I want to speak a bit about how I see Article 2 within my work, within my research, and then refer to two papers that I have authored during the last years, and the kind of highlight the relationship between Article 2 and the withdrawal from the European Union, and with Brexit as an example. So, okay, so for the ones that do not know me, I'm working during many years on pretty much the same question, which is the relationship between EU law and the right to self-determination, right? So mainly what I'm working on is how EU law and the EU legal order treats the right to self-determination, treats self-determination movements. And generally speaking, the argument that I'm always making is that the EU legal order is very flexible and it can accommodate self-determination movements, right? Now, how does Article 2 relate to this kind of framework? In two ways. The first one is that it's often the case that when we have a self-determination conflict, that both sides within the EU, that is, both sides of the conflict would make a claim about Article 2, right? So if we think about the events in 2017 when Catalonia organized this referendum that led to the independence of Catalonia for 15 seconds, both sides made an argument about Article 2. So the Catalans would say, well, actually, the Spanish authorities would say the Catalans are actually violating Article 2 because they are organizing a referendum that is completely unconstitutional. They have passed some laws on the transition that they don't pass the muster of democratic procedures. And on the other hand, the Catalans will say, well, Spanish authorities are actually breaching Article 2 because, on the one hand, they don't allow us to express our self-determination aspirations. And at the same time, you know, there was this major overreaction of the Spanish police, to put it mildly. So that's one way that there is this kind of tension of Article 2 in my work. But there's a more important implication of Article 2 in my work. When one studies EU law, self-determination, often what you try to study is the limits of the EU legal order. So how can we stretch the EU legal order in a way that we can accommodate potential constitutional solutions to those problems, right? So, the typical example here would be, the unification of Cyprus. How much can we stretch the EU legal order in order to make sure that we accommodate that? And in my work, and to go back to a debate that took place yesterday, what I'm trying to show is that, generally speaking, there is flexibility to the extent that whatever constitutional solutions are found are not in violation of Article 2. So what I'm trying to argue in my work is that Article 2 is perhaps the only undemandable part of EU law. Now, in my work, I don't go as far as other people that say that, Article 2 is kind of the eternity clause. I still believe that the European Union is a constitutional order of states, as Dasut has said. So in that sense, they're the masters of the treaties, and they can rewrite the treaties. But within this constitutional framework, in a way, and to go back to what Bernice has said 30 years ago, Article 2 provides for the limits to the constitutional tolerance of Article 4, paragraph 2. Okay, so now that I have explained that, well, let me go first here. And what I'm arguing with regard to Brexit, the withdrawal of from the EU, and Article 2, is that despite the fact that Article 50 and the Article 50 right is unconditional and unilateral, and I'm going to explain those terms in a minute, still the whole process of the withdrawal should conform with the Article 2 values. So it is an unconditional right, it is a unilateral right, but if there is a limit to this Article 50 right, if there is a limit to the right of a state to withdraw from the EU, it can be found in Article 2. So I have developed those points into articles, one that I have authored with an eminent scholar, the Capelletti of our generation, and it's forthcoming. And the other one is an article that was published last year. So let me take through the arguments that we have been making in those two articles. So in this article that it's going to be published in the North Carolina Journal of International Law within the next month or so, fingers crossed, what we try to see with Giuseppe is a number of crises, of constitutional crises within the EU, Grexit, Brexit, the rule of law crisis, and we try to make sense of them within the framework of two paradigms, two examples of contestatory federalism. Nullification, that is issue-based withdrawal, so when a constituent state wants to be out of the federal pact, but not completely, just a part of the federal pact, and secession, so when a constituent state wants to get out of the federal pact completely. And what we try to do by comparing those crises with the historical example of the US constitutional experiment is to show that all those crises, through the lens of nullification and secession, are vehicles of constitutional conflict. So they are expressions of constitutional conflicts within this. So they are not extra-legal instruments. They are actually instruments within those federal orders. And to a certain extent, although they can be abused, and they have been abused historically, but politically, and we saw, so many presentations about how, with the rule of law backsliding, we have an abuse of those tools. Still, in certain cases, they have been used as tools to protect, or at least ostensibly protect, from abusive policies from the center. Now, the EU, and this is the difference with the US experiment, is so flexible, and that goes back to my initial argument, that it may accommodate this kind of crisis to the extent, again, that the Article 2 values are not violated. So let me now go straight to the relationship between Article 50 and Article 2. Now, the Article 50 right belongs, according to Friel, to what we call. So Friel, let me go a step back. Friel distinguishes between three kinds of secession rights. The federal primacy right, pretty much when in a federation, federal primacy model, where a federation bans completely the possibility of secession, the possibility of withdrawal from it. The federal control right, control model, sorry, when within a federation, there is the possibility of withdrawal, there is the possibility of secession, but on certain conditions. Think about, for example, the situation in the UK. Northern Ireland has a right to secede, but in order to do that, the relevant Secretary of State has to be satisfied that there is a majority that wants that, and then, of course, there have to be two referendums that would be approving such secession. And then there is the very rare model of state primacy or sovereignty model, state sovereignty model, where the relevant federal order gives an unconditional right for secession. And that's where Article 50 is situated according to Friel. And we see that in the first paragraph of Article 50, which says that any member state may decide to withdraw from the Union in accordance with its own constitutional requirements. So this is a unilateral right, in the sense that any member state at any moment can actually push the button and get out of the EU. And in fact, if you read Article 50, you will see that it says that there are two ways for the end of this process. Either there is a withdrawal agreement, as fortunately we had in the UK, or after the expiry of 2 years, then automatically the EU treaties cease to exist. So it is as unilateral as it can get, because the moment that is the button is pressed, and unless the member state changes its mind, it leads to the withdrawal. So the federal level has no say over it. It can make it very difficult, and to a certain extent the EU played its card to make it difficult. But you can reach the end of it. It's also unconditional, and if we compare it with other secession rights, constitutional rights of secession, from Liechtenstein to St. Nevis and Kitts and all those constitutions, or Ethiopia, we will see that there are also no conditions. So there, in the case of Ethiopia, if I'm not mistaken, there is a clear condition that there must be a negotiation about the budgetary arrangement and economic accommodation, for example. And it's so unconditional that the Court of Justice in Whiteman, it said that not only a member state has the right to withdraw from the EU, but also it has also the right to withdraw from this notification if this withdrawal of notification is again is unequivocal and unconditional, right? So they really have changed their minds. I remind you, Whiteman was a case that was brought through a preliminary reference procedure from the highest court of Scotland for civil matters, the Court of Session. Whiteman was a member of the Scottish Parliament for the Green Party. For the ones that don't know, the Scottish Greens were at the forefront of Bremain, so they are avid, they used to be avid Europhiles. So he brought a case in order to clarify one of the dark spots of Article 50, which is, okay, we trigger Article 50, can we revoke the notification? And despite the submissions of the institutions, which the Commission and the Council submitted that they would have wanted certain conditionality on how the withdrawal notification would take place, the court said no, the Article 50 is so unconditional that this encompasses also the right to withdraw from this notification, again, if it is the withdrawal, if it is unequivocal and unconditional, and it's not a tool to abuse the system, let's put it this way, because that was kind of the fear of the Commission and the Council. However, what I have been arguing alongside other people like Tridimas, Makruden, and so on and so forth, there is a limit to the unconditional and unilateral nature of Article 50. And this limit can be found in Article 2. Now, I remind you that, as I said before, Article 50, paragraph 1 says that any member state may withdraw from the European Union as long as it respects its national constitutional requirements. And Tridimas has powerfully argued, and in papers, but also more importantly, Makruden has argued that in front of the UK Supreme Court, because Makruden was part of the team that pleaded in Miller, have said that, okay, this is true. At the same time, the courts can actually check whether this respect to the national constitutional requirements follows, doesn't breach the common constitutional traditions of Article 6, paragraph 3, and the Article 2 constitutional value. So let's speak a bit about those two cases. So in the first case, in the case of Miller, again, for the ones that do not remember, what happened was that precisely because the UK doesn't have a codified constitution, there was a genuine question: what are the constitutional requirements for triggering Article 50? So what does the unwritten, well, the uncodified, I was about to say the unwritten, and I'm always saying to my students, it's not unwritten, it's uncodified. What are the requirements of the uncodified British Constitution in order to trigger Article 50? And is it the government under the executive power, under the royal prerogative that can do that, or is it the parliament? And that was a genuine question. In fact, in the beginning, the vast majority of the commentators were very much in favor of the government's position. However, the Supreme Court made clear that actually the uncodified British Constitution, who cherishes the idea of parliamentary sovereignty, so Parliament is the main locus, the main actor of constitutional politics, should actually trigger Article 50. And at that moment, there was pretty much kind of a tacit understanding that, okay, the Parliament approved the notification, so pretty much the Article 50, paragraph 1 condition has been satisfied. And one of the few people that argued differently was Eckhout with Franju, who said that, you know what, if we want to have a process that would be respecting the common constitutional traditions, Article 50, paragraph 1, but also Article 2, it's not enough to check how it has been triggered, but we have to check, generally speaking, whether the whole process is in conformity with all those principles. And that brought us to Cherry, the second Miller case. Again, for the ones that they don't remember, that took place in 2019. It was in the summer of 2019, a month after Boris Johnson was elected, and the UK was about to leave the EU at the end of October. And in order for Mr. Johnson to be able to frustrate the will of the Parliament, because Parliament was about to block his Brexit policy, he prorogued the parliament, so he stopped the parliamentary session for 50 days, right? And the court said that that was against the British constitution. So it is clear here that, you know, the respect to the common constitutional traditions, respect to Article 2 values is something that is a necessary condition in order to be able to withdraw in a legal, in a lawful way. And the second way, according to which Article 2 is relevant here, is again has been highlighted by Tridimas, who said that the EU, of course, when it would be signing the withdrawal agreement, and that comes from Cadi, it is bound to respect the EU treaties and its higher constitutional norms, including Article 2. Now, of course, one has to also say that, you know, this respect to Article 2 and this review of Article 2, it can only be a very light review. Because, I mean, let's think about a situation whereby, you know, the highest national court in the UK or the Court of Justice would have found that the UK has breached Article 2. What would be the outcome of that? I mean, the outcome would be very paradoxical, because the EU then would have to, you know, start an Article 7 process on a member state that wants to leave. So it's like, you know, in the Victorian times when suicide was unlawful, so it was the only crime that you were getting caught if you were not you were not doing it, if you were failing to actually do it. So it would have been a completely paradoxical situation. But from a law point of view, from a theoretical point of view, Article 2 is kind of a limit to Article 50. Okay, final thoughts. Not many. Not many. We'll see. So the final thoughts is that to go back to those two papers, is that as I said, in my understanding, Article 2 provides for kind of a limit to Article 4, paragraph 2. It kind of provides a limit to those big constitutional decisions. And precisely in this paper of the Virginian Journal of International Law, one of the points that I'm trying to make is that, well, let me go a step back. There, what I try to do is to show that any kind of secession within the EU, whether it's at the internal level, the external level, or withdrawal, it has to conform with Article 2 if the EU is to accommodate. Precisely because Article 2 provides for a limit to all those processes, it shows also that within this very postmodern and fragmented constitutional order, still there is a core, and this core can be found in Article 2. Thank you very much. Good.
Thanks indeed, Nikos. Lorenzo, I think we can stop the recording, so we can start the Q&A session.
Thank you. So,
A bit of editing after
yeah,
this.
this is a signal that we have to approach the end of our discussions. Well, thank you, Giuseppe, for moderating this final session. And first of all, I would like to express my gratitude to all of you, Mattei, Pietro, Gaetana Morgante, John Moraine, for making it to Pisa, for participating in this conference. And I am also grateful to Lorenzo for his help yesterday and this morning. Now, I have learned a lot since we are still, let's say, facing a moving scenario. We are on a frail ground. My first thought in listening many of the interventions during the conference is what is the status of Article 2 TU and the related provisions within the EU constitutional order. We have listened to a number of possible answers. For instance, Pietro Paraguna yesterday was taking a quite a strong stance against the idea of a sort of a fixed hierarchy within the EU constitutional order. Nikos, just before, mentioned this, he has used this adjective non-derogable, I think non-rebuttable, even in the absence of an unamendable core properly understood of the primary law of the European Union. So this is an emerging point, and well, it's here to stay. Even the debates about the constitutional identity of the European Union, if you adopt a definition of identity as the non-modifiable part of the Constitution, either implicitly or explicitly, as Yaniv Rosnai put it in his monograph. Well, all of this doesn't contribute to making things easier to understand and to detect. Another point, as I argued yesterday, much of the ongoing discussions concern the rule of law, but may go beyond the rule of law. This was particularly evident, for instance, in Anna Wójcik's presentation. So there is a rule of law component understood as the status of judges and other constitutional organs. But there is something more going on, even in the rule of law restoration process in Poland, which affects also other dimensions of the constitutional order, including a symbolic dimension and, well, also some organizational and financial concerns in the broad sense. So the focus is mainly on the rule of law, but there is something more than that. In theoretical terms, well, I have just taken a look at Frank Shortkoff's book review, so the book review that Professor Frank Shortkoff wrote about some monographs, including Dimitri Špika's book on EU values and courts, and Professor Shortkoff complains about what he calls an under-theorization of this subject, and well, to some extent, I think that this is unavoidable because we are far from moving in a, let's say, really settled legal landscape. So some forms of uncertainty and under-theorization are, let's say, a non-issue in my view. For instance, the distinction between principles and values, the possibility of making a clear-cut distinction between them when let's say, raising points about how to operationalize these tools. And my very final point on the some of the conclusions that I drew from these sessions yesterday and today is that, let's say, this debate is not a fixed one, and the political context, at least in my view, is a quite problematic one, because we are, let's say, confronted to a number of different processes, including the so-called politicization and even parliamentarization of the European Union. And if you move from the idea that these processes are going on simultaneously, this may lead, well, to, let's say, quite a number of difficult issues. For instance, the risk that was evident in some parts of Matej Auber's keynote speech yesterday of an over emphasizing of, say, a comprehensive approach to the founding values. Mattei was pleading in favor of a more, let's say, classical liberal approach to the founding values, and was warning against the risks of a comprehensive approach to them in times of polarization and politicization. And this, I think, is an emerging challenge that the existing circumstances will not contribute to resolving in the near future. So these are just some hints that I got from your presentations, and well, I'm really grateful for all the let's say the food for thought and the further elements that emerged during the debates. Now, my idea in practical terms would be to launch a book proposal on some of the issues that have been addressed during this conference, and I will get in touch with all of you quite soon to ask if you are willing to contribute and well, to define some, let's say, more practical aspects. Now, I think that not so much the timetable, but the warnings that come from the regional agencies are, let's say, something which exerts some pressure. So I will stop here. And again, many thanks for this contributing to the positive elements and the success of this conference. Thank you. Bene. So,